Well, hello everybody, and welcome back to Buckle Up, It's the Law. Folks, you have questions, I have answers. Today we are going to be doing a special video. About 24 hours ago, I tweeted that if you have any questions, please feel free, and I'm going to create a video answering all of your questions today, 7 p.m. Eastern Daylight Time here in Kentucky, and I'm releasing this video at that time. Basically, there are about 44 questions. I'll see if I'll get around to all 44 of them in this one video, or if we're going to split it up into a couple of videos. I imagine it shouldn't take very long. So without further ado, let's just dive right into your questions. Some of these might be stupid. I'm going to cover them anyway. I think it's fun, especially when I love when people try to make fun of me, because I've learned in this game, you got to have very, very thick skin, and it's not that complicated. So whenever somebody insults you, trust me when I say this, just lean into it. You'll see what I mean after you watch this video. Don't forget to like it, comment below, subscribe to the channel, hit that notification bell. Let's go. Haley Elizabeth asks, what is the process of hiring an outside entity to be a special prosecutor for a city or the Commonwealth? Are there certain stipulations that need to be met? Are there budget caps on how much a city can spend? So when there is a conflict, usually, this is a unique case where there's not really a conflict. With Lally, for some reason, they decided to bring outside counsel. Maybe they owe Brennan something for the Whitey Bulger case when he got creamed and wiped the floor with his face in Norfolk County. Back in those days, 20, 30 years ago, whenever it was. I think they owe Brennan something. That's why they brought him on. They said, look, you do this, we'll pay you $250,000 or whatever. There are no caps, really. It's taxpayer money. Obviously, if it's money that the office has, they can spend it. It's a really good question. So usually it's when there's a conflict. It happens in Kentucky all the time. All the time. When the prosecutor knows my client, like personally, they'll just bring an outside prosecutor to deal with the case. Or I have one where I'm representing a lawyer. And of course, the lawyer knows the prosecutor in the county where he's being prosecuted because it's his home county in very, very small town Kentucky. And as a result of that, they have to bring in an outside prosecutor to prosecute this lawyer, because otherwise the other prosecutor has a very, very long-standing relationship with this lawyer. So that's not proper. I've seen judges do this, prosecutors do this. This is very common. But usually, again, it is limited to situations where there's a conflict. Now, Maybe Lovegood Law asks, we've all seen many shenanigans in this court. We certainly have. But from what I understand, appellate courts review matters of the law and not the underlying facts. That is also correct. If she's convicted, meaning Karen Reed, of anything, what appellate issues have you seen that are likely to be taken by the circuit? That is a very, very thick legal question, and I will try to answer it thus. There are a myriad of law issues. Now, how strong are they is obviously going to be a question for the appellate courts. I have not been paying close enough attention as some people like Emily, Andrea, Melanie, who have been watching every second of every minute of every day of this trial. They can probably answer that question better. I have not seen anything that is so glaring other than expert witnesses that should have never testified in the first place, like Shanon Burgess, for example. 100% should have been excluded. He should not have testified due to his lack of credentials and lack of expertise. But short of him, was anything so egregious? I can't, nothing really comes to mind from a legal standpoint. Because remember, if there was something illegal happening in the courtroom, Jackson and Yannetti and Alessi and Little would have raised insane umbrage by now, and this case would have been stopped. From a illegality standpoint and something that is so glaring, unfortunately, I can't really pinpoint any moment in time where it was like, oh my God. Bev knows what she's doing. She knows how stupid this case is. The facts are completely moronic. We know that John O'Keefe was killed by a dog and a human, not a car. But because of the corruption, because it's a cover-up, they have to go through the motions. And unfortunately, they're doing the procedures, at the very least, they're doing them in the right way, and they know what they're doing. That's unfortunate. Now, next, Carolyn J says, can the defense bring up that the Commonwealth has changed the timeline since the first trial? Last year, he was hit at 12:45 a.m. That is a fascinating question, and it's extremely crucial for this jury, you would think, to know this information. But unfortunately, in closing, the defense is extremely limited to what they can and cannot say. Now, obviously, the jury has already been tipped off that there's been a previous trial. However, there may still be some way to hint at the fact that some things have been changed, and you don't have to say, in the first trial, this happened, and today they said this. You can say it in a different way. Like, previously, this witness has testified implied that 12:37 or whatever, and today or now they're saying 12:45. That's how you get around that. Excellent question. Dr. Matt Curley asks, Buchanan says the word integrity an awful lot. I think Jackson would have scored huge if he asked him what the definition of integrity is. Maybe, maybe not. That's a loaded question. It's not really a question. This is more of a statement. But you may be right. You may be right. California Dreamer asks, can the defense try to have all of Proctor's evidence thrown out under the doctrine of fruit of the poisonous tree? Here are my thoughts on the probable cause. I will simply say that the answer is no. It would have been done by now, and it would have been filed, and I'm sure it has been filed, and Bev denied it. So moving on to the next question. It's still an excellent question. Annabelle Higgins. I love this question. Why did Court TV cancel your appearance? Is it because of your knowledge of the Karen Reed case is superficial? It's because I know absolutely nothing, and they realized that I'm a complete sham of an attorney. I was really hoping that I would be able to squeeze my way in as a false and fake lawyer who knows nothing about the case. Unfortunately, they picked up on the scent. They realized that I'm an absolute nobody who knows nothing, and at the last minute, they axed me, and I was like, damn it! So I almost squeezed in. I was really hoping to get the reputation of Court TV and the credibility of Court TV behind my back, but unfortunately that hasn't come to pass, and probably maybe never will. I don't know if I'll get reinvited. I've been discovered as a fraud and a sham and a liar and a deceiver of all sorts. And by the way, that whole answer was written by Julie Grant. Shout out to you, Julie. All right, next question. Donna Q. Please explain why previously respected attorneys would publicly give their biased opinions on the case. Any case, not just this one. Gives me ambulance chaser vibes. So you have to understand, attorneys such as myself / reporters, because I am reporting on a case, I'm acting in a dual capacity. Number one, I don't have a fiduciary duty to Karen Reed or her team, nor do I have a fiduciary duty to the court, nor I have any fiduciary duty towards Brennan or Lally or the prosecution or any of the witnesses. I'm an independent entity. I can say whatever I want. I can do whatever I want. If I look like a fool, so be it. If I look like a genius, so be it. I am simply stating my opinion, as is every other law tuber on the planet. And if you don't like it, then go watch something else. We don't owe an obligation to you to say what you want us to say. We are going to say what we believe is the truth. At least from me and my channel, I can tell you from the bottom of my heart, I will always speak my opinion. And at some point, you guys are going to start seeing this very soon. I'm going to have sponsors. I'm getting there. I'm already getting emails. I'm being flooded with emails, sponsor this, sponsor that. And I'm turning people away. I'm like, I don't believe in your product. I don't believe in your service. I don't care how much money you're throwing at me. I am not going to sacrifice my integrity and my professionalism just because you want and I can make $10,000. Ooh, oh my gosh, $10,000 is a lot of money. But all I have to say is I love this AI feature that you got. Why? No, I refuse. I'm going to promote my firm, 1-844-774-HURT. If you need an injury lawyer, call me, obviously, because I know me. It's me. Because it's me. And at some point, you're going to start seeing products and services being featured on this channel. And I will wholeheartedly tell you that I will only promote the products that I believe in. I will only promote the ones I believe in. I don't want to be a sellout. That is the worst thing that anybody can do. Because once you're a sellout, that's it. There's no going back. You can't turn back the clock and say, wait, I'm sorry, that was a fluke. I got paid $250,000 for that one, so I threw everybody under the bus because, I don't care about you guys. But I care now. I care now. Now that you hate on me, I care now. Like, come on, dude. Don't be a sellout, okay? Right, Logan Paul? Don't be a sellout. CoffeeZilla knows what I'm talking about. Anyway, next question. Prefer No Name asks, can they waive jury instructions on lesser included offenses and let it all ride on just murder too? Yes, it's a qualified yes, but if the instructions have already been submitted, the modification thereof, again, it all depends on what Bev does, because Bev does very unorthodox, non-traditional, corrupt things, so anything is possible, but I don't think it's a good idea in the first trial. But now you got my gears grinding. This question is actually making me think maybe it's a good idea in trial number 2, let it ride, because the facts are so much worse this time around, because Brennan is doing not a half a job. He's barely doing a quarter of a job, 10% of the job that Lally did. Lally got everything out. And now the defense is going to bring all these people in. The defense is going to call Higgins and Proctor and Brian Albert and Colin Albert and Allie McCabe and Matthew McCabe and Trooper Paul, the doctors potentially, the nurses from Good Samaritan. I mean, they're gonna, and of course we have Lucky and Dr. Wolf and the other ARCA witness. So the other Dr. Wolf, not the brain surgeon. So there's at least 20 witnesses the defense is going to call, almost guaranteed. So the trial is going to last another 2 weeks, I would say. We're going to be done sometime in mid-June, by my prediction. I predict that we're going to have a verdict by the middle of June. Jennifer Miller asks, can the defense check the jury slips when the final jury is chosen, and is the defense present when they draw, so Bev is not selecting the final jurors? No, that is done by the court and the court clerk. James asks, can the defense ask Trooper Paul whether he agrees with the prosecution's new timeline and argument? Possibly. He will have to be alerted ahead of time to review the testimony, and as an expert witness, although expert is such a loaded term, Trooper Paul could theoretically do that. And if he does, James goes on, does that imply that he was wrong in the initial case and possibly mistaken in others as well? Absolutely. 100%. Great question. Nobody asks, not a question, just watched your video on Shannon the Liar. You had me in stitches. You're welcome. Next question. CP1 of 3 asks, if KR is found not guilty and November 26th, DA Morrissey gets voted out, can the case be reopened and get that other DNA tested? Yes, 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 and yes. And even if it ends in a mistrial, still yes. The new DA, remember, I always allude to this because this case is so amazing. The trial of the Chicago 7 about the Chicago riots in the 60s, the new administration came in and they decided to prosecute, but Ramsey Clark, the attorney general in the former administration, elected not to prosecute. A change in administration could change the course of this case. If Morrissey does not win re-election, if he gets voted out and somebody else takes his spot and they're like, I don't want to prosecute this anymore. This is not my dog fight. This was Morrissey's fight, and I'm not gonna entertain this crap, this garbage. They can just stop prosecuting. Even though we don't have a verdict, it's going to be in limbo if there is no not guilty across the board, and if there's no guilty across the board, which is definitely not going to happen. So the chances of a not guilty is now increasing exponentially, with Brennan completely screwing the pooch and throwing the case under the bus by doing a quarter, 10% of a job that he should be doing. The defense might have a chance at across the board, not guilty, not guilty, not guilty. If they don't get that, if it's going to be a mistrial because of a hung jury on any issue at any point, then absolutely the new prosecutor can say, no lo prosequi, don't wanna do this, stupid. Carrie asks, do you think there are stealth jurors on this case? What does that mean, stealth jurors? Do you think jurors are making up their minds already? Absolutely. Absolutely. Most jury studies, and I subscribe to this school of thought, juries make up their minds in the opening of the case. Did you hear that? I did not misspeak. I did not have an aneurysm. I didn't suffer a stroke. The jurors decide the victor and the loser with like 95% certainty in their minds after opening statements are concluded. And 99% of the time, they will stick to that decision unless something catastrophic happens during the trial that makes them change their mind. Think about that for a second. When Brennan and Jackson gave their opening statements on April, was it 22nd? Yeah, exactly 1 month ago, on April 22nd, 2025, Hank Brennan and Alan Jackson gave their opening statements to the jury. At that point, their opinions have already formed as to who they think, or excuse me, not who they think, but do they think defendant is guilty or innocent already. Now, of course, their opinions may fluctuate, and the reasons behind why they may think what they think is going to be very, very fluid. But for the most part, the rest of it is just confirmation bias. That's why openings are so important. So important. I learned that very on in my career, and that is why I win more trials than I lose. That's why people call me, 1-844-774-HURT. That's why people call me and hire me on their cases all across the country. Criminal, civil. Primarily right now, I want to do more civil work, because criminal work you have to pay out of pocket, and it gets very expensive. There's no reason to hire me outside of Kentucky for criminal work for the most part. But I do a lot of stuff, obviously, and especially DUIs. I have cases all over the country. I've been to about 1/4 of all states already. And let me tell you, folks, when I say that the jurors have already made up their mind, they're not supposed to. But unfortunately, it's inevitable. It's just what happens. Every single jury trial I have ever conducted, jurors have pretty much all but admitted to me that, yeah, we kind of made up our minds. You had us in the opening. If they believe you, you have already won. Now you just need to prove it. If they don't believe you, you've lost. And maybe you can prove otherwise. Good luck with that. But if you can't, you've lost. If you can, you have a chance at winning. Great question. Heather C asks, didn't they say John didn't have frostbite? We would have had frostbite if he was outside the temperatures winds 5.5 hours, at least to his face, ears, hands, and shoeless foot. That is an excellent question, and I hope the defense brings that in cross-examination or in their case in chief. Bev, oh, the judge is here. I'm kidding. Somebody called Bev. The bloodstains on John's shirt bother me. If John died from falling backwards as they claim, how did the blood droplets get on his shirt? Gravity? Hello? Excellent point. Totally agree with you. Jessica Spradlin, I hope I'm pronouncing that correctly, asks, what, if any, consequences will the Commonwealth face after the second attempt at prosecution against an innocent woman? Free Karen Reed. They won't, probably. Unless the feds decide to completely tear their place apart. Nobody important at all asks, how did blood or vomit get in John's underwear? Why is John's right sock on upside down at the ER? His left shoe was missing, but not the right. Imagine putting socks on upside down so the sole is on the top of the foot. Well, I mean, if he just put his socks on wrong, that's, I don't know what to tell you. Denise Kelly asks, are you going to bring up the fact that the basement was resurfaced? Are they going to bring up the fact that the basement was resurfaced? Maybe. Don't know. That's up to the defense. Does Bev have no oversight? Yes, she does, the CJC. How does she get away with her decisions and obvious bias? Because she's the judge. And the oversight is minimal. It's only for egregious violations and abuse of discretion. Who oversees judges? The CJC. Ray Pato. Larry, first of all, I'm a big fan of your show. Thank you, Ray. And tell everyone into this case to subscribe, and they all love you. That's awesome. Thank you so much. My question is it legal for the Commonwealth to do what they did with Burgess? Sure. It's idiotic, but there's nothing illegal about it. Making a plan during trial, I mean. Changing the facts and changing trajectory is egregious. No judge other than Bev would have ever allowed it. And because Bev is allowing it, the jurors are even more confused, and that's always good for the defense. Jury confusion is a W for the defense 100 times out of 100, because confusion equals not guilty, or at the very least hung jury. So the more confusion, and if the prosecution is responsible for the confusion, even better. That means they don't have their shit together. You know what I mean? Why has no one brought up the difference in the sneakers? I guess the defense didn't see it as important. Next question, High Scroller. That's a cool name. I want to know how Court TV finds defense attorneys who are publicly pro-prosecution in this trial, and how they can be trusted with future clients after their public figure against finding Karen Reed innocent. Look, there will always be people who are irrational, either don't care, or are paid actors. AKA, what's her name? Wendy Murphy, Grant Ellis Smith, whatever his name is, mother. There are obviously Collins' attorney. They're all just corrupt. They don't care about the truth. They'll just say whatever they need to say, and they're probably getting paid on the back end. I get paid by YouTube to say what I believe. I don't get paid extra by like Karen Reed and her team. Like, hey, thanks for saying that. Here's an extra, couple grand for your opinion. Get more information out there. Can you make more videos, Larry? I only get paid by the platform because people are watching. And obviously people like what I say because I have a couple videos that have, from this trial, from this year, April and May 2025, that have hit 1/3 views a piece. I think I have 3 videos that have already hit 1/3 and that's just in the last month. That's insanity. That means that whatever the heck is happening in the courtroom and whatever it is that I'm saying about the case, people like. Other people may say other things about the case. It's just, everybody has an opinion. You've heard the phrase, opinions are like a-holes, right? Everybody's got one. Some are just more valuable than others, and the audience gets to decide which is which. Kelly asks, can the crash daddies bring up that they weren't hired by a car insurance or private party in the beginning? Sure, if that's the fact, yeah. I know Bev won't allow them to say the feds hired them. Correct. Swan Lake Lady asks, why wasn't the tow truck driver called in to testify? Because that's going to be the defense's case in chief. And why wasn't the vehicle covered up to protect any evidence that may have been on it? Again, just give it time. It's probably going to happen either next week or the week after. Tammy McCarrow asks, can Shanon Burgess's academic dishonesty lead to other cases he has been on as an expert in being overturned or retried? Absolutely. Lori M., if John was hit by a vehicle backing up and, as Wolf stated, would have had to fall backwards, hit his head on hard surface, being incapacitated, how did he end up where he was found? Well, according to Trooper Paul's testimony, he flew through the air for 30 feet. Moron. Was his exact location ever brought up by either side? Did the police not document this? No. And this is going to come out in trial number 2. In trial number 1, this was all brought out. Trial number 2, we have nothing because it's ridiculous. That's why Trooper Paul hasn't been called. His testimony is completely idiotic, and the defense should absolutely call him. How can the defense bring a context or an explanation to Karen Reed's media clips without calling her? Maybe a closing? Yes, closing for sure. Or calling Karen to the stand, which I don't think is a good idea. Never let your client testify, not because they are guilty or innocent. It doesn't matter. We all know Karen is 100% innocent. It's risky, especially if you're winning. I have had one case where the jury told me, Mr. Foreman, we were with you the entire time, and my client was 100% innocent. But when he took the stand, he wasn't a good witness. He started saying stupid things that made no sense. And I'm like, why is he bringing this up? And the prosecutor just kept poking and prodding. He was a young kid. He was like 23 in a very, very small county in Kentucky. And at the end, the jury convicted him with no jail time. And I asked them, why did you convict? And they're like, we didn't believe your client. Had I not put him on the stand, I may have won that case. That's the day that an innocent man got convicted. I didn't even have the advice for him, don't testify, because I thought he could hold his own, and I was wrong. He just started saying things that made him look worse. And some of that stuff I didn't even pick up on until the jury pointed it out to me after they convicted. So never put your client on the stand unless you're absolutely 100% sure they're going to help the case. If they don't help the case, do not put them on the stand. That's rule number 1 of criminal defense. So they can talk about it in closing. Absolutely. Zach asks, why even try this case after all the damage the first one caused to the Commonwealth? Are they mentally slow? Well, I'm not going to answer the second part of it. That's a little cruel to call them out like that. But at the end of the day, honestly, I just think that there's so much corruption, they don't care anymore. They just literally don't care. Morrissey is going to lose the election in 6 months, and he just doesn't care anymore. Future Flash, this is not a question, this is a statement. There is no question. She did it, meaning Karen Reed. Go away. Okay. Well, thank you all for joining me. No, I'm just kidding. All right, let's keep going. Kentucky Heather, how likely is that a higher court could find bias in this judge's rulings, the second trial only? I feel, so this is very similar to a previous question. I feel it's way more obvious this go around. I agree, but that's for you, not the jury. The jury's seeing this all for the first time, so you gotta remember, microcosm. Say there is another hung jury, which is likely. Would there be a reason to throw her off the case? Maybe, maybe not. Is she untouchable? She is very untouchable, unfortunately. Here's a great question by Samantha Ayers. How's long to die in the cold? It's a great question. Jules Jolene asks, can Bev be called out for her loud size and obvious bias against the defense? Yes, in the court of public opinion. No, inside the courtroom. Ray Pato, again. Oh, you're the best. Thanks, buddy. Mark Bedwetero. Anyone that believes your one-sided version of events is as big a brain-dead moron as you are. Okay, that's not a question, that's a statement. So nice job following instructions. And secondly, what else you got? Next question. If John was hit by Karen's vehicle, why didn't John's iPhone detect the crash? Ooh, black box on the iPhone. Interesting. What kind of a moron are you? The best kind. Thank you very much, Bill Slaughter 29. Virginia Coroner. Catherine Peters is not on the witness list. Oh, interesting. So, okay, it's not a question, it's a statement. But, okay, thank you. Marcus Burks says or asks, the bias of Aunt Bev is obviously to include hindering the First Amendment with the buffer zone. How is this allowed? Well, it's obviously been overturned by the circuit already, and she had to fix it, which she did, and I think it was too minimal, but whatever, and permitted to be the way the judges rule. The part of the Karen Reed trial is this could be any of us. Very, very true. That worries me that I could get stuck on the wrong end of my own Auntie Bev. I mean, look, it's possible. Anything is possible in life. That's the unfortunate reality, but hopefully it won't happen to most of us. Let's just put it that way. Mad Dog Photo asks, I know judges can be recused in Florida, aka the Jeremy Hales case, obviously, all 50 states. But can the judge be recused in Massachusetts per, there's a link here. I don't know if there's enough desire to prove that the judge is acting with bias. They've tried to remove her many, many times, and each time it's just not going anywhere because her violations are, although egregious from a factual standpoint, it's the judicial disqualification motion to recuse chapter that is cited. I just clicked on it. So we don't need to go into too much detail, but let me just say that, yes, it sucks. Yes, she should be recused. No, she hasn't been yet. And like I said, just wait. The truth is coming. Everything will come to light in due course. Just give it time. Bev is 5 years from retirement, forceful retirement by the Massachusetts judicial canon rules. She will reach, I think, age 70 or something like that. She's like 65 now. And at 70 is mandatory retirement. So she'll be replaced no matter what. But I think it will happen much sooner than that. So anyway, thank you guys for all your questions. Again, don't forget to like this video, comment below, subscribe to the channel if you haven't already. And I cannot wait to see you guys in the next video. No court today, tomorrow, Saturday, Sunday, Monday. We're going to be in court back on Tuesday. So I have tons and tons and tons of content for you all that I'm going to continue cranking out while this break is happening. So I'll see you all in the next video. Bye, everybody.